All right, welcome everybody. Welcome to the Institute for Corporate Governance and Finance's Roundtable on behalf of my co-director, Rob Jackson, and our chair, David Katz. I'm really thrilled to welcome you to the program. This is the kind of program that I love. There's an issue here that is deep in the weeds at the intersection of antitrust and securities regulation and corporate governance that potentially has huge implications for corporate governance. And it's some of those implications that we're trying to explore today. And let me share my screen to give you some sense of what I see as the framework set up to get this issue going. So, as many of you know, Hart-Scott-Rodino was enacted in 1976 to solve a particular problem. And the problem was under Clayton Act Section 7, the Principal Merger Control Statute, that on the remedial side, enforcers were frustrated because when the companies had already merged, it was extremely difficult to, quote, unscramble the egg. It was difficult to convince courts to enjoin the parties to separate once they had merged. And that very much constrained the remedial options for the enforcement authorities. The solution to this problem was Hart-Scott-Rodino, an advance notice that imposed an advance notice and waiting period to give the antitrust division and the FTC a chance to object. And it has a number of pieces. First, as any deal lawyer knows, business combinations, business consolidations can happen by merger, by stock sale, or by asset sale. And so any sort of waiting period advance notice statute is going to have to capture all three. So the trigger in Hart-Scott-Rodino, these are the current numbers, they vary from year to year. It's triggered if the acquiring person will hold more than $200 million in stock or assets of the target, or the acquiring person will hold between 50 and 200 million, and one person has the sale or assets of greater than 100 million, and the other person has sales or assets of greater than 10 million. Now, what this means is that it is very, very wide. So in addition to being very successful at solving the unscrambling problem that motivated Hart-Scott-Rodino in the first place, it's often triggered well before 13D is triggered. And so it has emerged as a significant factor in M&A as an early warning system where issuers become alerted to accumulations of their shares prior to the 13D 5% filing trigger being triggered. There are two principal statutory exemptions in the Hart-Scott-Rodino Act that are important for our purposes today. One is C9, which exempts acquisitions solely for the purpose of investment of voting securities if, as a result of such acquisition, the securities acquired or held do not exceed 10% of the outstanding voting securities, or acquisitions, again, solely for the purpose of investment by any bank, banking association, trust company, investment company, important for our purposes, or insurance company, of voting securities pursuant to a plan of reorganization or dissolution, or assets in the ordinary course of business. And those are the two, each of those is triggered by this phrase, solely for the purpose of investment. And as we'll see, the interpretation of that phrase is very much at the center of our discussion today. Now, there were a number of issues arose in the years in which Hart-Scott-Rodino has been in effect. One is that there are many, many, many filings and very few challenges. And that immediately raises the question whether the system be made less burdensome by exempting some portion of the filings that are not going to be challenged. And the FTC's notice of proposed rulemaking, which is the center of our discussions today, made two big changes. First, it defined person at the asset management level, not at the pool of assets level, with this new term, the ultimate parent entity. For a family of mutual funds, the ultimate parent entity is the management company, not the individual mutual fund. Second, there's a blanket exemption for acquisitions of less than 10%. And that exemption has a number of exceptions to it. One is, it doesn't apply if the acquiring person is a competitor of the issuer. It doesn't apply if the acquiring person holds greater than 1% of a competitor, the 1% exception. And it doesn't apply if the acquiring person has a vendor-vendee relationship with the issuer of more than $10 million in the last fiscal year, the so-called vendor-vendee exception. What's not in the NPRM, but is clearly at the center of the FTC's interest in its advance notice of proposed rulemaking, is a potential reexamination of the FTC's understanding of solely for the purpose of investment. Now, let me say a few words about how these issues are connected, because they're deeply, deeply connected. If solely for the purpose of investment is interpreted to include the normal stewardship activities by mutual funds, then defining the person as a UPE or the scope of the 10% exemption may not matter very much, because the large institutional investors would be exempt under the solely for the purpose of investment. On the other hand, if solely for the purpose of investment continues to be narrowly interpreted, as we'll see that the FTC has historically done, then the 1% exception and the vendor-vendee exception may exclude large institutional investors from taking advantage of the 10% exemption. And here's the key link with corporate governance. That if large institutional investors need to comply with HSR notification and weighting requirements, they have quite a simple way, I think, of complying with the existing interpretation of solely for the purpose of investment, namely putting their shares in the drawer and being utterly passive other than voting. And that, in my view, would come at a significant cost to corporate governance. So how does the FTC interpret solely for the purpose of investment? In its 1978 Statement of Basis and Purpose, a key document for the interpretation of 7A, solely for the purpose of investment is defined as voting securities are held or acquired solely for the purpose of investment if the person holding or acquiring such securities has no intention of participating, and now this language is quite broad, in the formulation, determination, or direction of the basic business decisions of the issuer. And the FTC's explanation there was that entities such as investment companies frequently engage in acquisitions that may meet the criteria, the size criteria of the Act, but they generally have no interest in affecting the management of the companies whose stock they buy. And that, of course, reflects a 1970s view of corporate governance, when, as we recall, when institutional investors really did nothing more than vote. They really had the shares in the drawer. That, of course, has changed over the years. And that's no longer an accurate description of what the institutional investors do. So the combination of the NPRM and the advance notice of proposed rulemaking raises a bunch of fundamental questions. Are institutional investors' normal 2021 stewardship activities consistent with solely for the purpose of investment under 7A, under the Hart-Scott-Rodino Act? Stewardship in 2021 is undoubtedly in tension with, arguably inconsistent with what the FTC has said about solely for the purpose of investment in the Statement of Basis and Purpose and elsewhere. But here's where I think things are quite interesting. As far as I know, and perhaps Commissioner Phillips can elaborate a little bit on this, the FTC has never gone after large institutional investors for not filing under HSR. They've gone after hedge funds that, in the FTC's view, have done more than hold the shares solely for the purpose of investment. But as far as I know, they have not brought any actions against large institutional investors who, of course, have been active in corporate governance for the last 20 years. Moreover, it strikes me as unclear how a court would interpret Section 7A if the FTC were to press the issue and argue that the institutional investors' normal 2021 stewardship activities go beyond solely for the purpose of investment. And that seems to me an unstable equilibrium that is calling out for clarification. So let me just say a few words about today's program and then turn things over. Let me stop sharing and reshare so you can see this document. So we're going to turn now to a fireside chat between my colleague Rob Jackson and Commissioner Noah Phillips from the FTC, who will talk about what the FTC is trying to accomplish with the Notice of Proposed Rulemaking and the Advance Notice of Proposed Rulemaking. We'll then turn to panel one, moderated by Rob Jackson, that will delve into how corporate governance works in 2021. How do the large shareholders interact with firms? And how might the Notice of Proposed Rulemaking, the proposed rules in it, affect corporate governance activities of the largest investors now? We'll then turn to the second panel, which I will moderate, which will look at how this could affect issuers. Because of course, if large institutional investors can't speak with issuers without triggering HSR reporting, then of course issuers can't speak with their largest institutional investors. And understanding from the issuer's perspective how important it is to have a robust dialogue with their largest shareholders is a factor that is quite important for these issues. Finally, our third panel, moderated by David Katz, will look at alternative ways to accomplish what the FTC is trying to accomplish. Because of course, the kind of transparency that is provided by Hart-Scott-Rodino is also provided by 13D, 13F, and 13G filings. And if we focus not on which agency is promulgating the rules, but instead focus on what sort of transparency is optimal for both the capital markets and the enforcement authorities, we may be able to think of different ways to accomplish the same thing without changing the corporate governance landscape. So with that, let me stop sharing my screen, welcome you again to the program, and turn things over to Rob Jackson and Commissioner Phillips.
Well, thank you very much, Ed. Welcome all. On behalf of myself, Ed, the Institute, and all my colleagues here at NYU, we are delighted to be convening today's important conversations about the future of these proposals at the Federal Trade Commission, and in particular, potential corporate governance implications related to those proposals. This is work at the intersection of antitrust and corporate law that has been occupied and really thoughtfully expounded upon by Ed Rock for decades. And we're very excited to be hosting it. And we're equally excited to be hosting my colleague and friend, the Honorable Noah Phillips, who will be kicking off the conversation with us this morning. I'm sure he needs no introduction in this audience, but I'll do it anyway. President Trump nominated Noah Phillips to be a commissioner on the Federal Trade Commission. He was unanimously confirmed in April 2018. Before that, he served as chief counsel in the Senate on the Senate Judiciary Committee. He previously worked at as a litigator, I should say, Cravath here in New York. And he began his work at Wasserstein, so a finance background as well. And he brings, I can tell you, that kind of seriousness and expertise to all of his policy conversations, including the ones I was fortunate enough to have with him. He graduated from Dartmouth College and went to law school at Stanford, but we at NYU forgive him. Commissioner Phillips, welcome this morning. How are you?
I'm well, thanks, Rob. And thank you for such a kind introduction. It's really good to be back at NYU. I'm pleased to note that the first speech I ever gave as a commissioner was on the concept of common ownership, and it was at NYU. And one of the things that fascinated me about the topics we're discussing today, and also about that topic, which is discuss is not unrelated, is this confluence where Ed has been looking at things for so many years between antitrust and corporate governance. And I think it's an area of confluence that is very important to focus on, in particular right now, as antitrust world goes through the throes of some real examination, some real self-reflection and some direction, both at the agencies, in the bar, in front of the courts, and very importantly, also maybe in front of Congress.
Well, that sounds right to me. And we have a lot to talk about, Noah. So welcome back to NYU. As ever, appreciate your leadership in the space. And I want to get right to it and talk about the notice and the advance notice. And perhaps we can begin just by talking about the impressions you had going in about on the day the commission announced its path forward on the subject. Maybe you can begin by talking a little bit about your own statement. My guess is our colleagues are aware of it, the statements of some colleagues on the commission, and the issues that were joined in those statements. Sure.
I also probably should give the caveat that, as you know, people in your former position and my position have to give, which is that what I'm going to say are just my own views, and they don't necessarily reflect the views of the commission. I love to add the thing that you first introduced me to, which is the concept that over time, my colleagues will come to my position, or at least hope. But one of the really interesting things we're facing here in terms of how a path forward would look are two big uncertainties. Right? The first uncertainty, as with any rulemaking, is what we do when we think about a rule is we put something out, we ask a bunch of questions, we get a bunch of answers, right? And then depending on what those answers show, we may correct course. And my understanding is the comment period closed a few weeks ago. I think it's February 1. And so as an agency, we're still in the process of gathering that information, going through it, evaluating it, and so forth. And the second big kind of unknown or known unknown is the composition of the commission itself. The commission that voted out both the NPRM and the ANPR was composed of 5 people. One of those people is gone already, our erstwhile chairman, Joe Simons, and Commissioner Chopra, my colleague, is nominated to run the CFPB. In DealBook this morning, they reported rumors that he may have a hearing with Gary Gensler for the SEC in March in front of the Banking Committee. What that means as far as when he will leave, we don't know. When we will have new FTC commissioners and who those people will be, we also don't know. So there's quite a bit up in the air. So I want to come back to your question. What was I thinking going in? And I think the best way to express what I was thinking is what I did express in my statement, which is an interest in one part of the NPRM in particular, which is something that I have talked about going back to the beginning of my tenure. And that is the idea of exempting de minimis investments from the obligations that they have today. This is not a new idea. And this is something that I talk about. And in fact, it was an idea that bubbled up pretty quickly after HSR was adopted, because there was a view that HSR, which is intended to allow us, the antitrust agencies, to get notice of a transaction before it happens, so we don't have to unscramble the eggs in court later. There was a view that it was already interfering with certain kinds of corporate governance and other investment-related activities in a way that wasn't related to competition. And so the agency sort of set out in the 80s to deal with this issue. They got a lot of pushback from Congress. In part, that had to do with the ongoing back and forth in Congress, in the states, at the regulatory agencies over, now we call them activist investors, but the sort of broader rubric of people that included leveraged buyouts and hostile takeovers, this sort of thing. I think a lot of folks in, Fortune 500 corporate boardrooms were not happy. And so the notion of this rule was somewhat unsettling to them. So there was a lot of pushback and the agency moved away. The facts on the ground then were that the transactions at issue, right? Investments under 10% never amounted to anything in terms of antitrust enforcement. And the facts on the ground today are no different. The only difference is that we have an additional 3 decades of experience that show us that these things continue just not to be that interesting. And there are a lot of filings, and there are costs to those filings, and it operates, as I discuss in my statement, as a tax. You, by the way, saw a similar statement from the Assistant Attorney General, Makan Delrahim.
Yes.
So that was his focus. That was my focus as well in terms of what we wrote. Obviously, there are aspects of internal deliberative process into which I cannot get. You also saw 2 other statements, the statements of the minority commissioners, and they were much more optimistic about the aggregation rule. The NPRM also contemplates grouping together in ways entities that that are not currently grouped together because of concerns in terms of how funds are managing investments and whether there are folks exercising control, and HSR isn't capturing that. And that was definitely a big focal point for my colleagues.
Absolutely. And let's talk a little bit about that. I wasn't long ago, I was in your shoes, Noah, so I know there's limits on what we can say, but I'm especially keen to think through Commissioner Slaughter's statement. She said something interesting, I thought, in her statement, and I reviewed it last night thinking about today's conversations. She pointed out that de minimis rules have policy implications that go beyond, for corporate governance and investor behavior, that go beyond the scope of the FTC. That may be true. I think that's observationally correct. The question is what to do about it. And I wonder if you can offer some reactions that you might have had to Commissioner Slaughter's thoughts in that respect.
So in a certain sense, I agree completely with her. And that's what my statement is all about, right? My concern is that in the service of catching anti-competitive transactions, we are chilling behavior that may be good for corporate governance, right? We'll see what the comments show, right? That's what the rulemaking process is all about. So I want to be clear. Everything I'm saying is sort of priors going in, subject to what we see.
Of course.
But my general view of Hart-Scott-Rodino, this has popped up recently, very recently at the agency in another respect, is that it should serve its purpose and really not any other. So Ed was talking earlier about how Hart-Scott came to be a warning sign, right? It came to be used in a way that was outside the scope of its intent. That's fair enough. But my point is, Congress's goal here was to allow us to prophylactically spot anti-competitive transactions. Goals beyond that are goals that we can well discuss in Congress. We can discuss it at the SEC. But at the end of the day, we should stay in our lane. So I agree with Commissioner Slaughter that these things have implications. I think where we disagree, my view is that we should minimize our impact on the market's operation outside the scope of what we need. Mm-hmm. What she's expressing is because this has implications one way or the other, we ought to sort of defer.
Right. Well, that makes sense to me. I think, Noah, one of the reasons we wanted to convene this conversation, and you heard this from Ed, is that there is no doubt in my mind, and I suspect the minds of many others, that what's been proposed would have very substantial implications for the market. The question is what the FTC should do about those implications. And as a former commissioner of the SEC, I would certainly hope that consultation as among the agencies is something that you're all considering. By the way, given that we're having this conversation today, Noah, I would be remiss. I'm not asking you to confirm or deny, but it was my experience that even comments received after the deadline can be useful and thoughtful for a regulatory comment file. Being a law professor, I prefer to take deadlines seriously, but is it me, or could it be that, continued engagement from the market would be a useful thing?
Look, my general view is that continued engagement on any issue is always good. In terms of what impacts comments can have under the APA for purposes of rulemaking, I'll leave for the administrative lawyers. What I will say is that while I haven't yet had the chance to review all of them, because again, the period closed recently, we have had a lot of input from a lot of folks who play in the market from different perspectives.
Sure.
And that is critical input to get. And we have to take that input seriously. That's our obligation.
Of course, that's right. I'd be remiss. You mentioned it, so I got to ask. You talked about recent debates around HSR and early termination, a long-standing practice that transactional planners have been thinking through and advising people about for decades. And there was a sudden change in policy there. And I spent some time reading your statement on that last night. I have to say, with this audience, one of the great things about being here at the Institute is we're talking to a lot of the very strongest transactional planners and investors on Wall Street. Tell us a little bit about your thinking about that policy change. And again, you can share a little bit about what you expressed in your statement.
Sure. So the policy change in question is, with one exception that's been announced, temporarily and indefinitely to suspend the practice of early termination. So for those not tracking, although I think a lot of folks here are, when you file HSR, you can ask the agencies and they in their discretion can grant you early termination. We're not interested, carry on. Otherwise, you have to wait. And as we all know, especially in markets, right, waiting can sometimes come at a cost. There are also publicity questions, and some people choose not to seek early termination. And in many cases, of course, we wouldn't grant it because we want to take a look at the thing. But in cases, I give the statistic of roughly half. That's a very rough statistic, and it to some extent varies over time. Half of transactions we've sort of just let go, and people can carry on with what they need to do in the market.
Sure.
That was suspended, and it was suspended indefinitely. And the statement that I wrote with Commissioner Wilson was that we didn't think this was warranted. The putative justification is that we're going through a leadership transition, that filings are up, and that we have the pandemic. And our answer to that was, well, sure, the pandemic started a while ago. We did have to suspend early termination when we switched our systems to accommodate the new way that we're working. But we've been back up online for the better part of a year.
Okay.
The second point on the increased filings, they peaked in November. And there's no indication that we have seen that we're unable to deal with what's in front of us. And then the third thing is leadership transition. That's something that happens. We didn't feel that that was a basis alone, and it never historically has been a basis to interrupt this market function.
I think that's right. And Noah, can you just share a little? I mean, I also took a careful look at Acting Chair Slaughter's statement that, she, as you say, she offered these justifications and others. I have to say, as a market participant and observer, one has to wonder whether there's some hidden message there about the intensity with which the review will proceed, about questions that should be expected to come from the staff. Early termination, again, is something that transaction planners have relied upon for some time. Can you say anything about that?
Yeah, I don't really know a lot about what review is in mind. What I know is that the program has been suspended, that we haven't seen in public announcements any indication of what we're looking for, what metrics we would use to judge. And I think we'll have to see. I don't know that there's a hidden message. I certainly always take what Acting Chairwoman Slaughter says at her word. What I do think this links up with, though, thematically speaking, is a very new approach to M&A markets in Washington that I'm not sure that folks participating today quite appreciate. Not everyone, but for a lot of folks in DC, an increasingly loud and powerful group of people, there is deep suspicion about the functioning of these markets in and of itself. So for instance, you saw, I believe it was over the summer, proposals by a number of prominent people, including the chairman of the Antitrust Committee in the House, to ban all HSR mergers, stop them outright. This was also echoed in proposed legislation by Senator Warren and Representative Ocasio-Cortez. And this comes from, I think, if I sort of take folks at their word, a much darker view than I think like traditionally coast-trained people would adopt about what M&A markets are doing. And a view that really there's a lot more harm going on than there is good, which of course, in the context of antitrust, would translate into a radical different approach to the error cost framework. Now, there are a lot of folks looking carefully at the error cost framework that we apply.
Right.
Thinking about, are we being bold enough? Are we being too timid about litigation? Those are, in my mind, fair questions.
Good. I'm glad to hear
However,
that.
I do think there is, in certain circles in Washington, and I'm not saying this is what the ET suspension is about, but I do think it gets picked up there with applause. There are certain folks for whom these markets really aren't that good. And they take a much more nihilistic approach to their functioning. That's not the view that I take. And I'm really concerned about using all sorts of tools to throw sand in the gears unnecessarily and unrelated to competition enforcement. But I do think that is an increasingly prevailing view. And it's not clear to me that folks outside of DC see it.
That's fascinating. And we could talk about that all day, because I feel one of the things that may be happening is and this happens in Washington, Noah, in my experience, I of course can't speak for you, but the pendulum has swung away from a world in which M&A is an unalloyed good, an argument about which I am skeptical, I should say, and an argument about which it is an unalloyed bad. Hopefully the FTC will find that the truth is more complicated, as is often the case. Let me ask you. I have to ask you squarely, man. They won't forgive me if I don't ask you, because everyone today is going to be debating. What do the words "solely for the purpose of investment" mean? And so I have to say, I've got an FTC commissioner sitting in front of me. I would be remiss not to ask, what do they mean to you, Commissioner?
Sure. So let me begin with reiterating a caveat I made earlier, which is, because this is part of an ANPRM process, right? Asking how we should apply it. I'm going to take very seriously what we hear in that process. So I just want to start with that. But Ed's account of the traditional approach of the agencies, which is take your shares, put them in a drawer, don't look at them, that's correct, right? That's how the agencies have approached it. My view is that a robust market for corporate control, a market that allows shareholders to give input and spur firms to compete, right? Shareholders interested in their investments making money for them, that is a better world for the management of corporations, that is a better world for competition. Something we've spoken about in the past, right? In the context of common ownership, there's some concern that you have these large asset managers and they own substantial shares in competitors, and the CEOs are kind of looking around and saying, well, gosh, I'm American Airlines, but my big shareholders also own Delta. Maybe I won't compete. I submit that if that is a real concern, and I've raised some questions about that issue, but if it is, one of the answers to that ought to be the shareholders that don't own commonly,
right? And
empowering them to sic the markets on boards, on managers, and make firms compete.
And as you'll as you noted at the top of our conversation, that that discussion occurred here at NYU during a FTC hearing that you kindly convened and even invited me to. I'm not sure a ton of SEC commissioners have testified before the FTC, and I'm glad I was able to join you for that.
Well, Rob, you were often fond of saying that at SEC you should consider competition, and I don't disagree with that. But I like to remind you that between the 33 Act and the 34 Act, someone was in charge.
That's right. That's right. It's true. And as I've argued a few times, that someone was the Federal Trade Commission. I have to say, I would be remiss not to ask you, Noah, about common ownership, because it's a debate that continues to rage. It's one that you've weighed in on, not just as a policy matter, but intellectually. I thought I would remind or point to you, and we could talk about John Coates' famous problem of 12 piece, because John Coates was my corporate law teacher and also a partner at Wachtell Lipton. And now he has a new job. He is the director of the Division of Corporation Finance at the Securities and Exchange Commission. And I wonder, Noah, if you can share a little bit about John's work, your thinking on common ownership and this problem of 12. And it may be that John's going to have to answer some of the questions he's been asking.
He very well may. Look, I thought his article was a fascinating one. I thought Jeff Owell's piece in the Wall Street Journal echoing it was fascinating too. To some extent, it maps onto the competition question in the sense that, the same people controlling one competitor might be controlling another. But to me, it raised kind of a more fundamental question. I don't know whether to call it democratic, but there ought to be a broader discussion about what we do about a situation where a very small number of people are making a lot of the decisions for a lot of the companies. My inclination is to believe that part of the solution is to allow market forces to operate, all shareholders to have a voice, right? We've got a long history in the academy and in the courts of developing, what are the rights of minority stakeholders within, minority shareholders within a corporation. But I think it raises a really interesting question. It's something Matt Levine has weighed in on, and I think it's going to, from the common ownership perspective, that's something the antitrust authorities are looking at. But the questions are much broader than that. Sure. Right? They're much broader than that.
Well, I think that's right. And I saw Matt's piece on this a few days ago. He's an old Wachtell classmate of mine. And I have to say, it struck me that there's a little bit of tension that John might now be facing. And I wonder if I could get you to talk about this. On the one hand, he and others are keen that the Vanguard, BlackRock, State Street, and the like push firms on matters such as environmental questions, social justice questions that are pressing and crucial. On the other hand, it occurs to me that engagement might be the very kind of thing that would raise concerns about a common approach among common owners to particular regulatory questions. So I wonder if there's some potential tension between this push toward asking institutional investors to do more, but not too much, lest they find themselves in trouble with you and your colleagues, Noah.
Well, I think the answer may come down to, well, what are they doing? Right? There's actually an interesting paper from a student, I think, still at Yale School of Management, Nathan Chiquita, and he responds to the call that I put out to the academy to study some of these common ownership questions, including what the mechanisms were. Like, show me examples. Is this just theoretical? Is it real? Is it active? Is it passive? And I do think you're seeing a lot from asset managers of talking to the market and what they think people should do. Some of that is obviously completely benign, right? We have a view one way or the other on a staggered board arrangement or executive compensation or whatever it is. But, obviously, if there were someone directing a bunch of competitors how to price, I'd be really concerned about that.
Sure. Well, that makes sense. And I guess, Noah, finding that line of engagement that is not just appropriate, but increasingly demanded by investors, but engagement that does not raise these kinds of concerns, I think that's going to be a big part of today's conversation. Let me ask you, one of the other things I have to point out is that you said in your statement, and it struck a chord for me, that the gray area in the investment-only exemption is really going to run some risk of chilling investors' activity. I think to the degree there's less clarity here, it might well have the kind of unintended consequences we've been discussing. So do you think a goal going forward, and again, subject to ongoing deliberations and the comment file, should a goal just be making it clear to the market what the FTC's expectations are in this area?
Look, I think clarity is always good when it comes to what the rules are as a general proposition. But I think there are other considerations that are also, right? You don't want a clearly bad rule, right? Shareholders can never talk to, right, the companies that they own. I think one of the other considerations that I have as well is you want to reduce transaction costs. You want to allow for beneficial input, right? Input that spurs competition from a competitive perspective. I think there are a host of other really important things to consider, right? Other benefits to that input, but some of the benefits, to be clear, are competitive in nature too.
Can you give an example?
Oh, I just mean that if you have, consider the world, right, of the 1960s and the 1970s. Your conglomerate CEO is sitting there with his unrelated and unintegrated assets, and he's at the golf club every day. I'm being a little cheeky here, but this is kind of the story that was told. And things aren't being run efficiently. And as a result, right, we may not be seeing the low prices consumers want, the innovation they expect. Companies may not be trying to grab share in markets in ways that are beneficial, right? The very nature of competition. I think in the main, on average, over time, that is something that good shareholder engagement can help stoke.
Sure. And as you and I have discussed, there are a number of ways in which antitrust rules, whether incidentally or intentionally, may be squelching that kind of engagement. And we're going to talk about that throughout the day. No, I want to ask one more sort of very specific question, which is, to the degree that the FTC is examining this, I would imagine that what's happening at the SEC on related rules might matter. Let me give you an example. My former colleagues made a proposal related to disclosure under to 13F disclosures, which provides a great deal of information regarding institutional holdings to the market. That proposal did not move forward. It's not my understanding that it is moving forward. I can tell you the market reaction was rare unanimity about the problems with that proposal. My question for you, Noah, is, does the best rule for the FTC depend a little bit on what the rule is at the SEC?
I suppose the answer is yes, because it's cast fairly broadly. You know, I think we obviously need to be taking into account what's going on. And to be clear, one of the things at which the ANPRM gets is the question whether we ought to align our standards, right? So that, you know, you're making whatever filings you are, and it sort of simplifies your life as a filer. And I think, you know, again, leaving other ceteris paribus, that's a good idea. I think the agencies on some level do different things. Right. Our job is to police competition. The SEC's job is to maintain the integrity of markets and protect investors, this sort of thing. Look, Hart-Scott-Rodino is a sort of transaction cost. Mm-hmm. I think it's a good one, right? Ed laid out one of the things that it helps competition enforcers with is spotting things early, but it also pulls us out of this awkward situation where we're suing after mergers are consummated to try to undo them, right? And so I think it's the right, like in the main, it's the right policy, but it was always a transaction cost. It was always going to impose some sort of inefficiency. My view is we ought to minimize it, right? And limit it to what we need to do our jobs. Other people may disagree, and that's fine. But it certainly isn't intended, statutorily speaking, to serve the goals, let's say, of the 33 Act or the 34 Act. Sometimes I think they can align, not always.
Right, sure. And of course, one benefit to borrowing from those other statutes, although, as you say, they're statutes of different purposes, is that the market understands the SEC's definitions quite well. So to the degree your intuition, as you shared here, is to have a less impact on existing market practices, folks in the bar here in New York certainly are familiar, for example, with SEC definitions in this area, which is why the ANPR questions on that subject were very important.
Yep.
So, folks, I know we've come to the end of our time. I have to just pause and say thank you to my colleague and friend, Commissioner Phillips. What's wonderful about talking to him is he is as much a policymaker as an academic interlocutor. He's an analyst of these questions, a testament to why it's a good idea to have folks of his background, including his work in financial markets, on these commissions. Noah, we're very grateful for your service and your time this morning. We hope you'll be able to stick around to hear some of the expert judgments from the market about what the path forward here is. And thank you again for sharing these insights with us.